Thank you, Attila, and thank you, ladies and gentlemen. Good afternoon. First of all, allow me to congratulate the organizers for a well-organized and substantive conference that brought all of us together from different countries, different walks of life, to discuss where our world is going with respect to harm reduction. My brief presentation will touch on 2 points. First of all, where are we in the US in terms of the regulatory framework? What are the latest developments? And what can change and how? And of course, I know the one topic that interests many of you, what is the status of our litigation, Nicapure versus the FDA? For full disclosure, I'm the General Counsel and Chief Compliance Officer of a company that produces e-liquids and distributes vaping devices in about 65 countries. Nicapure Labs, we're based in Florida. Our manufacturing facility is in Gainesville, Florida as well. And certainly that is a conflict of interest because certainly we believe in these devices and in these liquids, and we believe that together with other non-combustible nicotine-containing products, they are the future. So, in the US, as you know, on August 8, 2016, the so-called deeming rule, the latest FDA regulation under the Tobacco Control Act, came into force, which really meant that all innovation came to a screeching halt in the US, meaning no new products can be launched and no changes to existing products can take place without a pre-market review by the FDA. And of course, FDA has not yet engaged in any pre-market review of any newly regulated product, including vaping products. Recently, as you know, a new leadership came in place at the FDA in the form of a new commissioner. However, the head of the Center for Tobacco Products, which is the division of the FDA in charge with combustible and as well as non-combustible and new nicotine-containing products, has not changed. He's still in place. Due to the handover, a 3-month extension of the various deadlines was granted to the industry, most notably the looming August 8, 2018 deadline for submission of dossiers for pre-market review of all products that were on the market on August 8, 2016. I'm talking about vaping products here. Certainly other regulated products like cigars could perhaps benefit from other types of pre-market review, but I'm mainly speaking, of course, about vaping products. So that 3 months extension, what it did for us, for the industry, it caused really a little bit of confusion. It was a message that to some of us perhaps, it's just a simple handover, it happens, but for others, they took it as a maybe sign that FDA may have changed their mind, and I promise you that it is not that easy for the FDA to change their mind, partly because wherever FDA exercised substantial enforcement discretion in respect to regulation that it has adopted, it has been challenged by advocacy groups. Just recently, FDA had postponed the deadlines for a disclosure on restaurant menus of nutritional values, and they were promptly sued by 2 advocacy groups that basically want FDA to enforce that reg in the timelines originally planned. What can change and how, given that, again, it's relatively rare for the FDA to sort of repeal of its own volition a rule as visible and as highly debated as this one, that is really a pillar of their policy versus or vis-a-vis vaping products and other newly regulated products. What can change is, of course, a good outcome in the litigation that our company, Nicapure Labs, filed immediately in May of 2016 when the rule was published. The status of that is as follows. We had expedited briefings sometime last summer, and oral arguments took place in October of last year before Judge Jackson. Historically, this particular judge has ruled an average of 6 months from oral arguments. In similar cases, however, it's been more than 6 months. And just recently, the Department of Justice, which litigates on behalf of the FDA, and basically it's the defendant in this particular lawsuit, has approached us and wanted us jointly to go to this judge and inform her of the 3 months extension that was granted to the deadlines in the deeming rule Fact being, I think, in all honesty, I believe DOJ really just wanted more time and maybe a little bit more comfort that a ruling wasn't going to be imminent. We did agree that we should inform the judge of this development, although I don't consider it material. But we also emphasized that we wanted the judge to consider our motion for summary judgment the way it was intended, meaning not withhold her ruling because of this 3 months delay. So we're expecting a ruling any minute now. We are aware that there are different outcomes that are possible, but we're also aware that from a legislative point of view, Congress is really not ready to tackle the entire Tobacco Control Act anytime soon. I'm also on the board of the Vapor Technology Association, and we engage at all levels of government, and we're fully aware that whatever attempts we had until now, unfortunately, didn't work out as planned, and in the immediate future, we cannot promise anyone that the law will be changed. That being said, of course, what I ask of all of you, and I'm aware that you come from different countries and many of you may not have any opportunity to engage with the FDA, but if you do have the opportunity, or if you can create that opportunity, in particular, I'm talking to the scientists in the room, please take that opportunity to inform the FDA of the way doctors communicate and reduce risk in countries such as England, the United Kingdom. Please inform the FDA of the results of your research. You may think it's an exercise in futility given that we already have a regulatory regime, but I promise you that it is not. If nothing, at least it will inform the way FDA reviews these products, if and when those pre-market dossiers are going to have to be filed. It is very imperative, and I just spoke to someone that I will not name who informed me that it was the first time that she was speaking with the FDA recently and was surprised that, in fact, FDA was not reaching out to the MHRA. It's very important that we all engage. You actually have a more credible voice. We are the industry. Of course, we're going to say that we want more reasonable regulation proportional to the reduced harm of our products. Of course, we're going to say that. But it's incumbent upon you to demonstrate, to bring the evidence in support of that hope. I will stop here. I'm very happy to take any questions. Of course, I will limit my comments to what's happening in the US because there are great experts on what's happening elsewhere on the panel. Thank you.